I'm Michael Green, the Clerk of Green's List, and I'd like to welcome you here this morning. I'd also like to introduce and welcome our chairperson for this morning's breakfast briefing, Justice Macmillan of the Supreme Court. Her Honour is a former list member who was appointed about 2 weeks ago, and therefore there was some doubt in my mind about whether Her Honour would have the time to chair this session, which she had agreed to chair before her appointment. But Her Honour very kindly rang me early this week and said no, she was happy to come along and chair the session as originally planned, and therefore I thank Her Honour. I'd ask you to welcome Her Honour Justice Kate Macmillan as our chairperson this morning. Kate, thank you.
I'm very pleased to present Theo Alexander, who's a member of Green's List. He's going to talk today about lessons to be learned from cases where there have been findings of unethical conduct, which will be very interesting. Theo's area of practice is commercial law, corporations and securities, criminal law in the appellate jurisdiction, intervention, compensation, licensing and disciplinary tribunals and trade practices. He's been admitted to practice since 2003, and he practices in the areas of regulatory and white-collar offences, Commonwealth prosecutions under the Crimes Act, the Criminal Code, Corporations Act, the ITAA, Competition and Consumer Act, and state prosecutions under criminal and OHS legislation. The civil part of his practice is company and commercial law. He acts for directors, officers and employees of private and public companies, advising and appearing in matters concerning civil penalties, director disqualifications and breaches of directors' duties. He lectures in undergraduate and master's programs at Deakin University, teaches in corporate crime, domestic, international commercial law and legal ethics, and to top it all off, he's also at the present time doing a degree of Doctor of Philosophy with a thesis entitled A Rational Approach to Sentencing White-Collar Offenders. It gives me great pleasure to introduce Theo.
Thank you, Judge, for that sales pitch. I've got some business cards too. That's right. I first did this at the end of last year, this talk, when I prepared it, and I just finished marking about 300 exams in legal ethics for Deakin University for my students. And in the course of preparing this talk, I thought to myself that if I had done my job properly at Deakin and taken the students through the ethical aspects of the practice of law and everything that they needed to know, and the average mark was a high credit, so I thought I haven't done too bad a job, then theoretically there would be no need, other than CPD requirements thrust upon us, for lectures like this. There really would be no need, would there, after all the training that we get, the experience that we have, the access that we have to the Professional Conduct and Practice Rules and the Legal Profession Act, for a seminar that's devoted entirely to legal ethics. I mean, it's very obvious that you shouldn't sleep with a client. It's very obvious you shouldn't sleep with your opposition's client, and it's probably very obvious you shouldn't sleep with both clients, especially at the same time. I mean, these things are not it's early. These things are not lost on us. However, in the course of preparing the talk, I had occasion to go back and look at the rulings of the Ethics Committee for the Law Institute, and also, more importantly, the decisions of the Legal Practice List at VCAT. So, indeed, it is true that ethics is very much grey, and it is difficult to find black and white. But what we know from the Legal Practice List at VCAT is that that's where things become black. And so what I thought was, for today, what we could do is, I've got 5 highlights from the last year's round of people who have taken a misstep in their practices. And what you'll see in respect to these is that it actually doesn't matter whether you're a law student who's just starting out, or whether you've been in practice in one case since 1970. you can still fall afoul at any point in your career. And although we like to think that it's always someone else and not I, it can ultimately one day be you if you're not conscious of the ethical consequences of your conduct. And so what I thought we would do is this. Firstly, is everyone familiar with the process of how the Legal Services Commissioner makes decisions about prosecuting a practitioner for misconduct? No? Quick refresher. Basically, two types of processes. The first is if the Legal Services Commissioner takes the view that the complaint that is investigated gives rise to unsatisfactory professional conduct, that he then will have a discretion if he thinks that there's a reasonable likelihood the tribunal will make an order against the practitioner, and that discretion is if you, in fact, just let me quote so I get it perfectly correct. He's got a discretion where there's a reasonable likelihood if you are guilty of unsatisfactory or professional conduct. He can A, take you to VCAT in any event, B, give you a reprimand or caution with your consent, and C, and most refreshingly, is that if you've been generally competent and diligent in his opinion, and B, there's been no substantiated complaint against you in the past 5 years, then he can choose to take no further action against you. So just rest assured that each year that ticks by where you haven't had a complaint made against you, that is ultimately theoretically beneficial for you. The other alternative is where he has no choice. There is no discretion. And in that case, this is 4.4.13 if anyone's interested. In that case, he has to present you to the legal practice list of VCAT, where he's satisfied that there is a reasonable likelihood that the tribunal would find the practitioner guilty of professional misconduct. So once you find yourself down at VCAT, then what we'll be doing today is looking at the options that are open to the tribunal. And I want to get your view about this conduct. In order to take a view on this, you need to be clear about the orders that they can make. There's two types of orders. One, orders requiring official implementation. That effectively means a recommendation to the Supreme Court that a practitioner gets struck off. The alternative is orders that the tribunal itself can make and impose, and they're many and varied, but just like in the criminal jurisdiction, they effectively start with a reprimand or a caution. They include a fine. They include an order that a practitioner refrain from working in a particular area of law, undertake a period of supervised practice, not apply for a local practicing certificate for a period of time, and various other orders that the tribunal might otherwise think fit. So if they're the options that are open for the tribunal, let's start with those people who have misstepped in the course of last year. First one, anyone know a gentleman by the name of Isaac Brott? Why does it always get that reaction? 6 times, 6 reactions. Right, well, Mr. Brott found himself before the legal practice list last year for an interesting process. You know, anyone aware of this deal that some solicitors have going? Obviously, times were tight and they thought that the best way to make some money was to effectively enter into an engagement with a panel beater. You know, familiar with this sort of process? Okay, so what they were doing was a solicitor would go and see a panel beater. Panel beater would advertise his services, crash and bash, no problem, come and see me, I'll fix your car, you pay nothing, I'll do the rest. That was the promise to the injured party. In the course of engaging the panel beater, what they would do is receive a document headed instructions to act. And the instructions were effectively instructions to a solicitor to act on behalf of the plaintiff in a crash and bash situation. Now, what Mr. Brott was doing, he had this deal going with a company called Elite Claims Management, who would repair the vehicle and in the course of it use his name, and he would then receive the document from them, and it says, I, John Elias, instruct you to act for me and to make a claim against me, make a claim against the other side on my behalf, and we'll discuss fees at a later stage. So the letter of instructions went. In the course of doing that, Mr. Brott sent a letter to Ligeti Partners saying, I have instructions to act on behalf of the plaintiff and I want X dollars for the claim. Ligeti Partners must have thought very carefully about this and thought, well, we're not sure if that's actually an accurate statement. And they challenged Mr. Brott on that assertion, and I think they effectively took it to the Law Institute. Investigation ensued, and consequently it was discovered that this process was being undertaken. Now, what do you think's wrong with what I've just said? Why would he find himself being taken by the LSE down to VCAT? What did he do? He's just drumming up a bit of work, isn't he? Uh-oh, they don't know. Uh-oh. Come on, this isn't a hard one. What do you think he did wrong? Sorry, who? Fees aspect, yes. Look, this might come as a surprise, but this is what the first charge read. The third charge. During the period December 2003 to November 2004, in the course of engaging in legal practice, you were guilty of misconduct at common law in that you purported to act as a legal practitioner for John Alias and commenced legal proceedings in his name without speaking to him, writing to him, clarifying his instructions, permitting him to obtain an alternative lawyer, advising him as to what damages he could recover, advising him in any way about the nature of litigation, or advising him in any way about the consequences of anything to do with embarking upon litigation. So it's generally a good idea to speak to the client before issuing a proceeding in their name. That's my first ethical suggestion to you. What would you do with Mr. Brott? Given the instant reaction about his name, I can tell you that he's 59 years old. He'd been in practice for about 40 years, I think. And in terms of his experiences down at the legal practice list, 85 complaint, 85 complaint, 86 complaint, 88 complaint, 1990 complaint, 2003 complaint, 2004 complaint, 2008 complaint. So, given the list of sanctions that can be imposed, what would we do with Mr. Brott? How serious is sending a letter to another practitioner saying, I have instructions to act, which technically he may have, but never having spoken to the client? What would you do with him? What would you do? Disbar him? Okay, strike him off. Anyone else? Worth striking off for that? Only a letter. He didn't actually charge any costs. All right, well, the legal practice list took the view that given his lifelong history of infractions, that it was probably time at 59 years old for him to retire, and they made a recommendation to the Supreme Court that effectively he retire, an enforced retirement by removing his practising certificate, and he didn't fight it. I think instead he just sold his building down the road there, and once he lost his practising certificate by consent, he's probably moved on to greener and happy pastures in any event. So that was Mr. Brott. Very experienced, but a little bit difficult in his practising life. I'm concerned this is being recorded and we do have defamation laws. So, difficult life. Qualified privilege, everyone. Now, number two, Mr. Comato. Very interesting case. He was the practitioner who'd been in practice since 1970. This is what happened. Mr. Comato had a child who was married. So he had a son and daughter-in-law. They were involved in a property development with a family friend, Mr. Saniti. Mr. Saniti and the two children needed to obtain a loan. They received the documentation. And are you all familiar with what a solicitor's certification is? Yes, right. Well, Mr. Comato received the solicitor's certification, was asked to sign it, did sign it on behalf of Saniti and his kids, and things went awry. Relationship due to the building probably fell apart, and payments weren't made on the loan, and you can imagine what happened next. You can imagine what Mr. Saniti was saying to the bank about the enforceability of their mortgage contract. And so Mr. Comato, who had done a favour for his kids and their friend who were doing some building, actually found himself with an investigation in respect of his signing of the solicitor certification without having explained the contents, without having explained what the guarantee means, and without having witnessed the signature of the person who signed the document. He simply just signed it and said, yes, that's fine. In practice since 1970, lots of recommendations and appraisals from other respected members of the profession, and described it as what he thought was a technicality. Yes, there's a judicial view on that view. Well, what do you think? What do you do with Mr. Cometeau? 1970, long time in practice. What do you do with him? Hands up, fine him. Hands up, simply reprimand him. Hands up, yep. Hands up, suspend him. Hands up, strike him off. Okay, good. Compassion is wonderful. Yes, that's right. And take your view about what the legal practice list is like in terms of their level of compassion. Order, respondent is reprimanded, aggregate fine of $10,000 and pay the applicant's costs of $15,000. So what that cost him was 15 grand, a reprimand and being raised on a day like this. Absolutely. Absolutely. Sorry. Yes.
I actually read that one because
Yes.
I was quite interested having heard about it, and I was actually quite shocked at how much, what it seemed to me, the weight the tribunal did give to the witnesses of credit, being barristers and such like. And I thought, what did it have to do with actually his understanding of his role as a solicitor? Whether you brief well, or whether you're a nice guy, or you know how to ask a legal question that a barrister likes. I was quite shocked by the way the tribunal looked at the problem and gave weight to the particular barrister that spoke on his behalf.
I take your point, and yesterday when I spoke to Leo Cussins, a group like this, about it, and by the end of these, they were quite prepared to go down to VCAT because they thought that the dispositions were so light that it was almost laughable. I only can say one thing in that respect. The purpose of professional disciplinary proceedings are not the punishment of the practitioner. The purpose of the disciplinary proceedings is the protection of the public from misdeeds by a practitioner. In this case, I quite agree that effectively by signing that document, he was lying. It was a written lie because he never saw someone sign that document, and it's almost akin, isn't it, to what would be the worst of all crimes, swearing a false affidavit. And signing that certification is probably akin to that. So I take your point about the way they view these, but certainly we must remember that we're not trying to punish, but rather to protect. And perhaps they took the view that in every other respect in his professional career, he could be a trusted member of the community.
Excuse me.
Yes.
I just want to make an observation about your remark that the Leo Cussin audience thought it was a bit of a doddle.
Yes.
I take the view, and colleagues with whom I work take the view, that the only thing you ever have as a legal practitioner of any standing of any time is your reputation.
Yes.
So anything which goes to reducing the value of that or besmirching your name is the single most serious thing that can happen to you, whether you're fined $5 or $500,000. So I'm surprised by the view of people who heard your presentation yesterday because I couldn't disagree with that more strongly.
Look, you're absolutely right, isn't it, that we live or die by our reputations in this profession? And the mere fact of being publicised, and these are required to be publicised, is, I quite agree, a significant penalty in itself. Interesting view. Here's another one who, very scant details in this case, but what I get out of it is this. This was a matter of Bernard Horsley, and Mr. Horsley was charged with effectively two charges arising from an application made by Mr. Luke Watson, his mother, Mrs. Janice Light. They obviously saw Mr. Horsley about making an application for victims of crime assistance, I think in 2005, and at some stage during the course of that, 2 years later, he was asked by them what had happened with their application. And he had falsely represented to the clients that it was actually struck out in 2005, and that was not the true position. Secondly, when other practitioners were retained by the complainants, the other practitioners sought a copy of the file to be delivered to them. And so it must have been a busy period of time between early August 2005 and early November 2007, because he failed to deliver the file to the practitioner over the course of those 2 years. So he was prosecuted and brought before the tribunal. No details about his plea material in respect of his background, but what do you feel that's worth? What did he do wrong, in a nutshell? Lying to a client and then trying to hide it by not providing a file. What do you do with him? Suspend? Here, suspend? Suspend? Anything less than suspend? Anything less than suspend?
Limit his ability to practice, not practice in that area.
Right, okay, so you think it's a competence question that he... Yes? Anything else? All right. Again, maybe this is why they came... He was reprimanded. So while you say suspend, given our instant reaction, he was reprimanded. Pay a fine of $2,000 and another fine of $500 and pay costs. About $10,000 and a reprimand for that conduct. That was 3. 4, almost there. 4. A practitioner that I know personally, lovely bloke, always competent practitioner, but found himself in this situation. Mr McNamara acts mainly in crime, but on this occasion acted for a Mr and Mrs Valier, husband and wife, in drawing up a will where a certain Mr Kerr was the executor of the will. During the course of Mr Valier's lifetime, he had promised the transfer of a block of land, it was worth about $75,000, to Mr Kerr, the then executor, before his death. Now, when he died, Mrs Valier then had a will drafted by Mr McNamara and made provision for the transfer of the land, of the property, to Mr Kerr. Now, all seems fine, except Mrs Valier, it was said, did not have testamentary capacity at that time. And Mr McNamara had available to him psychiatric reports saying that she lacked that testamentary capacity. But notwithstanding that, he prepared the will. Secondly, Mrs Valier died with that will, and then Mr McNamara commenced acting on behalf of Mr and Mrs Kerr, the executors and the beneficiaries, in respect of, against the estate, in order to try and get the property. Does that make sense? Okay. Okay. In short, again, what did you do wrong? 2 conflicts. Absolutely. What was the conflict? First conflict.
Can't actually the trustee and the actual people that own the trust.
Yes, and certainly not in circumstances where he'd prepared the will that he's now contesting on behalf of the beneficiary. And of course, the first one, the testamentary capacity, why would he have done it? Someone hazarded a guess yesterday, but wasn't he just trying to give life to the wishes of Mr Valier by including in the will those requirements? Look, maybe it's obviously hypothetical. However, he's been in practice about 30 years. He said his life was a bit difficult at that time, many things going on. He couldn't focus. There was some financial pressure. There's no other complaints made against him. In every other respect, a reasonable practitioner. What would you do with him? Reprimand him? Right, we've lowered our sights a bit. Okay. Reprimand. Anything else? Suspend him? Like they don't have a lynch mob option. Yes. Anything else? All right, this was one of the ones where they used their powers. All right, what Mr McNamara got was the following penalty. Respondent shall not act as a solicitor for executors or beneficiaries or administrators of deceased estates until he's undertaken workshops in relation to conflicts of interest equal to 10 CPD points. So that's not too bad. You're forced to sit through 10 hours of this stuff. I mean, it's a penalty in itself, but it's not too bad. And reprimanded for his conduct. He was also ordered to pay $25,000 in legal costs. And someone said, yes, oh, that's very high. And I looked at why that was, and for the Legal Services Commissioner was a silk and a junior, so I thought they must have probably applied the 2/3 rule still. So that was a significant penalty in that one. Last one, he was a very experienced practitioner. This last one's a very inexperienced practitioner. Mr. Nguyen worked for Sportsco, employee practicing certificate. Went out on his own and worked for Waterford Green Lawyers, his own firm, full practicing certificate, entitled to hold trust monies. Left that, went back into private practice at Gaydon's Lawyers. Went back into employee practicing Gaydon's Lawyers. During the course of his private practice in the middle, he did a bit of conveyancing work. Obviously being Vietnamese, he had some Vietnamese clients that undertook some conveyancing, and he acted in respect to that conveyancing. In an interesting twist of fate in terms of the timing, he had some files, he stopped doing file work, he still had an office with a receptionist. He'd changed his practicing certificate with the LIV, and he had effectively closed his practice. Except one day the purchaser in the property, he was acting for the vendor, the purchaser came in this last file with two amounts, $1,000 cash and $8,500 cheque. He wasn't there, receptionist took it, and then when he found out the receptionist took it, he just transferred it on to the vendor. He did not receipt that money, he just passed it on. The purchaser complained, where's my receipt? Went to the LIV, investigation occurs. What did he do wrong? Didn't have a trust account, didn't give a receipt, and what was the status of his practicing certificate? Can't receive trust money. So three strikes and they were pretty much clean bowled, or however that expression goes. So, now, new bloke, 3 or 4 years in the job, and what would you do with him? He said, but I did nothing. I just handed over the money. I didn't touch it. What should he have done? What should he have done? Yes, firstly, he's not done it. Two, if he did get the money because the receptionist took it, what do you think he should have done next? Send it back? Interesting. Someone said yesterday, bank it in Gaydon's Lawyers trust account. I'm not sure about that. It would have maybe caused more trouble than it was worth. Anyway, what would you do with him? Honest mistake, he said. And in fact, any financial penalty, he said, will bankrupt me. I have no money. Gaydon's have fired me. This has ruined my life. What would you do with him? Sorry, say that again? More workshop punishment. It's like some sort of labour camp. You will learn. What they did was this. In fact, it was a significant penalty this time. Not permitted to apply for a practicing certificate for 12 months. Prior to him receiving a practicing certificate over a period of 12 months, he needs to engage in 10 CPD points about keeping trust accounts. He can't re-engage in legal practice on his own account unless he first holds a practicing certificate for 12 months, and he has to pay the costs of the applicant. So in terms of, they took a much dimmer view about his conduct, saying effectively, you don't know what you're doing if you didn't realise this was effectively controlled monies or transit monies and you've engaged in this. But as we all know, the way trust money problems are viewed is always more serious than perhaps other ethical problems. So they were 5 great examples of what happens when you misstep. And on that last point about the grey, can I just read to you this? Because I said a lot about the professional conduct and practice rules, and these things are very obvious examples, but in many respects, what you do in the course of your practice isn't obvious, as Michael pointed out. Steve Marks, the New South Wales Legal Services Commissioner, gave a speech to some young lawyers, and he said this: "The rules of professional conduct are merely a framework of statements that describe ethical behaviour. They are not ethical rules or principles. They are only a baseline of conduct and should not prevent lawyers from acting as they would ordinarily do. Good ethical practice thus involves the legal practitioner considering the impact of their actions on justice, the integrity of the legal system, and the impact of their decision on the preservation of relationships." For Professor Postema at University of North Carolina, this means treating clients not as objects, but as humans, and applying our wisdom based on our world experience and knowledge. According to Professor Postema, we are not only authorised to raise moral issues with our clients, but we have a professional responsibility to do so. Good luck for the rest of the year avoiding the minefields. Thanks.